We would request next Mr. Amlan Mohanty, student of National Law School of India, University, Bangalore, to discuss the topic copywriting education with our access. This is a very, very important issue which we are grappling with in WIPO Standing Committee. We are discussing possible treaty for limitation exceptions for educations and research institutions, which obviously will be blocked by the EU and the US. So, very interesting topic. Mr. Amlan Mohanty.
Thank you, sir. Am I audible? Yeah. Good morning, everybody. So, the title of our paper is Copywriting Education with or Access. Now, I think out of all of the topics that we have, this is perhaps one of the topics that is most relevant to the theme of this entire conference, which is there a fair balance? And I think this is one of the topics that the students here might be able to relate to more than the experts, perhaps. So, I'll begin first with a brief overview of what I will be discussing. Number one, the current educational exceptions. So what are the exceptions in the Indian Copyright Act that can perhaps apply to enhance access to education and information? Number two is the problem of access to this academic material, which is what makes these educational exceptions so important. Number three, if not fair dealing, right? So I'll get into what fair dealing is. If not fair dealing, then what? What are the proposed alternatives from both sides? And lastly, we evaluate the amendments and look into the future as well. Now, why is this issue important? Let's begin with how courts in India have historically dealt with the educational exception. We found that this has generally been liberally interpreted. So some of the issues that have come up is the preparation of guidebooks, for example, right? So courts could have perhaps taken a restrictive analysis of, lots of copyright infringement, substantial copyright infringement, but courts have been in India have been generally liberal, have allowed for preparation of guidebooks, copyright over exam papers, right? So if I were to reproduce this in a textual form to assist students preparing for an exam, again, courts have liberally interpreted this. But I think the most important issue is perhaps something that all of you might be aware of, a recent case wherein a group of publishers, namely Oxford, Cambridge and Routledge, have sued Delhi University and interestingly, Rameshwari Photocopy Services, which is a photocopy shop located within the premise of Delhi University, which photocopies, and I've put this in highlight to this, which is course packs. Now, what are course packs? These are essentially extracts of particular textbooks, short extracts, not necessarily cover-to-cover reproductions, short extracts that are now compiled into what is called a course pack, right? So, this particular case, which is currently being litigated in the Delhi High Court, raises a couple of interesting issues with respect to the educational exceptions. But we think the implications of this particular litigation is so widespread because not only will it consider the legality of course packs, but perhaps also how much of a particular textbook I am allowed to photocopy. So yes, it relates to the legality of course packs, but for any students here who need to photocopy material for a moot court, for any kind of research purposes, this is a particularly important case, and we're afraid that this might be setting a bad precedent. So very quickly, let me look into the educational exceptions that might apply in the Indian Copyright Act. Right? So basically, where should students, teachers and institutions look to for protection? Number one, reproduction in the course of instruction. Now this is an extract from the Indian Copyright Act itself in section 52(1)(I). So the word reproduction, how should we analyze this? Right? Now we found that there is no statutory definition, neither is there a definition in any of the international statutes. So how do we begin to analyze this? From an analysis of a lot of case law and legislation, we find that the connotation for reproduction is essentially copying. What does that mean? Duplicating or making a reproduction. Right? I know it seems ambiguous, but reproduction should be interpreted as widely as we can, as possible. More importantly, we find that in other jurisdictions that contain a very similar educational exception, there is a prohibition, an express prohibition against the use of reprographic processes in the idea of reproduction. What that essentially means is that some statutes, for example in the UK, Hong Kong and Singapore, say that while reproduction is permissible, you cannot photocopy, right, which is a reprographic process. But our point basically is, the Indian Copyright Act does not have this express prohibition. It says it in the definition sections defines reprography, but in the section relating to reproduction does not make an express prohibition. So why read in a limitation when it does not exist? The word course of instruction, or rather the phrase course of instruction, we believe should be widely interpreted to include all forms of impartation of knowledge. Right? So whether I'm studying something in class, in the classroom, outside of the classroom, if it involves instruction, any form of manner, we think that this particular educational exception should be applicable. More importantly, we also think an end user test, right, is very, very, very important in this particular case, which is who is the end user of this particular material, right? And why is this important? Because a lot of arguments might come forth which possibly argues that Rameshwari photocopy service, which is the photocopy shop involved in this process, is actually the one benefiting from this exception. Not necessarily so. It's the students are the ones using these course packs, it's the teachers who are the ones using these course packs, and their purpose, their end objective must be considered. Lastly, the underlying rationale for this exception in the first place must be considered. This is where I think technological advances are very important, and I was giving someone an example of this a couple of days ago, which is that just think about how perhaps my dad, right, used to take notes. What he used to do is go to the library, sit down with a big fat book and make notes, handwritten notes. I don't think anybody would object to this particular practice. The only difference in 2012 is that we've moved away from that. Right now, I can use a photocopy machine and make that exact copy in 5 seconds. And do you really want to be restricting that particular action because of a technical definition of reproduction? We don't think so. The next exception, fair dealing for private use, including research. Right? This is found in section 52(1)(I). Now, what does private use mean? In a Canadian decision that was delivered very recently in 2012, they found that the word private does not necessarily mean something in isolation. So whether this is in a classroom with a bunch of students, still applicable. More importantly, the research, private study, and instruction are unified purposes. So whether it's the teacher instructing, the students using it for research or private study, all of these are unified purposes and should be read together. And keep in mind that in the Alberta decision, the Canadian Supreme Court very recently actually upheld the fair dealing application to circulation of extracts. So this is very similar, if not identical, to course packs. And if the Canadian Supreme Court seems to think this is fine, we don't see why India should hold differently. The second issue is the issue of quantitative limits, right? So this also comes up in the question of how much of a particular textbook I'm photocopying. So let's say it's a 300-page textbook. Am I allowed to copy 35 pages, 50 pages, 60 pages, right? So that becomes an issue from the part of the publishers. We think, again, that quantitative limits are antithetical to the idea of fair dealing in the first place. So it would be very, 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 very narrow way of thinking to say only 30 pages out of 300 should be photocopied, right? So as anyone who's worked on a moot before, what if the most important point is on page 32? Am I just supposed to not copy the last 2 pages because it's more than 10%? We think that's a ridiculous proposition. More importantly, N.S. Gopalakrishnan in the annual survey of Indian law has very expressly commented that in certain cases where books are available, unavailable, out of print, what other option do we have than to reproduce the entire book? So he notices that in some cases, even cover-to-cover reproduction is permissible. So quantitative limits, 10%, 12%, 5%, don't make sense to us. What is the consequence of reading down section 52(1)(I), right? Is basically all scholastic activities. Now everyone's looking at this from the perspective of course packs and whether these should be legal or not. But as soon as you start drawing limits on how much I can photocopy, right? Again, like I said, 10%. All scholastic activities, primary right up to tertiary, right? And more importantly, we need to consider that education doesn't end with graduation. There are research scholars working on these, working in areas where they require the use of academic material and reproduction of this academic material, right, for various educational purposes. And that should also be safeguarded, keeping in mind this particular education exception. Moving on to the next issue very quickly, the problem of access, which is what makes the educational exceptions so important and why there needs to be a wider reading of it. So, number one, the prohibitive cost of textbooks, right? So, first of all, I don't think anyone disagrees that textbooks cannot be purchased by students. All of the textbooks prescribed in a particular course, some of the reading material lists that I have from the National Law School, and this is based on a study that we've done, it's ridiculous, right? So it's about 12,000 for legal methods, about 13,000 for history. I don't think anyone argues that students should be purchasing these books, right? Then who purchases these books? It's the libraries. But then again, the issue becomes, how many copies can a library actually have, right? So for example, I have an international trade law study of the cost of international trade law reading material. We found is something to the range of £5,000. Yes, the National Law School of India has a fabulous library, but I'm sorry to say we can't have more than 2 copies of a particular book, right? Which is what makes not only the library exception so important, but also photocopying in general. So again, this is some of from the textbooks used in the Delhi course packs. These are some of the prices. We find that this is something close to 20,000 rupees for a particular course. Again, are students of Delhi University expected to purchase all of these books? No. Can the library, Ratan Tata Library in Delhi University, have multiple copies of all of these books to cater to the 70 students in an MA Sociology course? We don't think so. Next issue about, even if these textbooks are highly priced, there are some textbooks which are just not available at all, right? So they're simply unavailable or out of print. A recent study done by PPIL has found that out of 1,500 books which are foreign titles priced in the range of whatever, something pounds, there are no equivalent low-priced Indian editions. So how are students supposed to access any of these books without engaging in photocopying? Now, let's go on to the proposed alternatives and see whether these are viable and feasible options, right? The one and only, I think, proposed alternative is the idea of compulsory licenses. So this is something that's been discussed already. But what does compulsory licenses mean in this particular context? Essentially, stop photocopying, obtain licenses from us. Right? Now, let's look at, before we even consider whether compulsory license is something that we should be taking or institutions should be taking, is there any value in compulsory licenses over and above fair dealing, which is already permitted under the Indian copyright as an exception? Right? So to make that distinction a little more clear, a compulsory license would involve Delhi University or even I as a student paying a publisher a certain amount of money and is that a question? No, sorry. Yeah, so the distinction again, compulsory license, I would have to pay a one-time fee and then I'll be allowed to photocopy whatever I want. That's fine. Fair dealing is an exception expressly provided in the Indian Copyright Act, which says I don't even need to take that permission. I can just sit in my room, photocopy 5 pages, 10 pages, 20 pages, whatever, without them even knowing, and it's completely legal, right? So is there any value in obtaining that compulsory license in the first place when fair dealing already provides for these exceptions? So let's have a very quick look at this. Compulsory license will apply to a very narrow ambit of works. It does not cover all works. So for example, in the US, some professors might be allowed to play a certain audiovisual clip in the classroom. In Canada, for example, they might not. So a compulsory license is very, very narrowly defined to include only certain sections of works and not all of them. Secondly, the issue that I've already raised about an arbitrary limit of 10%, one chapter, 20 copies, this is again ridiculous. This doesn't bode well for education at all. Thirdly, potential for monopolistic practices. This is something that we have empirical data for as well, where in Canada, for example, the compulsory licensing society has now raised prices as much as 1,000%. And lots of Canadian universities have absolutely no way to pay these things and basically have discontinued their licenses, right? So once you give the power to the hands of the publishers to be dictating these prices, there's no way to know where it's going to head. So basically, we're favoring the interests of publishers over the students and the hardship that the students will face. More importantly, there's no case-specific determination. So, for example, if I were working on a moot and I need 50 pages, and I should potentially be allowed to copy these 50 pages, no one's going to consider my specific purpose. They're going to have an arbitrary limit of 10%, whether you're working on a big research project, small research project, all the same to them. Then the issue of copyright self-censorship, which is, again relates to the idea of institutions discontinuing these compulsory licenses because they just can't afford them, right? So institutions now have to be selective about what licenses they want. So do I want a JSTOR license? Do I want a Westlaw license? Do I want a Manupatra? Whatever, right? It's an issue of selecting between three when all of them should technically be accessible to students. Right? So let's look on the issue of fair dealing very quickly. 2012 amendments now extend fair dealing protection to all works. Right? So if I were to be able to claim a fair dealing exception, whether it's a film clip that I want to show my students, whether it's an extract that I want to circulate to my students, all of these are covered under the fair dealing exceptions. On the other hand, most importantly, we think there's no maximum limit prescribed under a fair dealing exception. So like Mr. N.S. Gopalakrishnan has mentioned, even a cover-to-cover reproduction is permissible if, for example, the book is absolutely unavailable in India. No maximum limit prescribed, no minimum limit. Again, publishers cannot dictate costs because I don't have to approach these publishers for permission in the first place. I can just photocopy 10 pages out of 100, never have to tell them. They have no idea what's going on, cannot dictate how much I have to pay them. Again, students are looked at as end users in a fair dealing analysis. Am I using it for a research purpose? Then go ahead. This is something that we think a compulsory license cannot and will not factor in. Again, the economic burden on universities is reduced. They do not have to procure these compulsory licenses and pass on the cost to the students. Right? So and ultimately we need to realize that the burden will be passed on to the students, whether it's the education institutions taking it on the first step or the students having to procure them individually. The economic burden is on the universities and students combined. And then lastly, basically all of these things that a compulsory license apparently allows, for example, scanning and photocopying, are things that fair dealing already allows.
You have 2 minutes.
I have 2 minutes. Okay, so very quickly, economic implications of obtaining compulsory license, we found that there would be more than 100% increase in the cost of course packs at Delhi University. So what currently costs about 500 rupees is going to cost 1,000 rupees. This might not seem like much, but think about the application of this compulsory license model across India. So it's not just Delhi University, it's a small university, it's in Bihar, it's a small university in Orissa. All of these students will have to bear the burden of this compulsory license cost. The international experience, as I mentioned, in Canada, several Canadian universities have discontinued their compulsory license model because they just cannot afford the 1,300% increase in these compulsory licenses. And if you thought that was crazy, Harvard University cannot afford these licenses. So what hope do we have? So just some concluding thoughts on the issue of access to knowledge. We believe that once this precedent, and just to clarify, the Delhi High Court has in fact passed an order against Delhi University and Rameshwari photocopy services, which essentially means that at some point they will have to obtain compulsory licenses unless this particular decision is overruled pretty soon. So we think that this particular decision can be used by the IRRO, to coerce all universities across India to procure these compulsory licenses. Again, universities will be selective with their subscriptions. In institutions where they do not procure these compulsory licenses, any kind of photocopying will be infringement right there, because the Delhi High Court has not recognized these as fair dealing exceptions and has rather mandated the use of compulsory license essentially. So any photocopying done in institutions that don't have compulsory licenses is clear infringement. Right? Again, this is something, the fourth point is something that we've already noticed in anecdotal evidence. I was reading an interview somewhere where a parent of a visually impaired child actually went to Rameshwari photocopy services and asked for a course pack. Again, he had to plead the order and say, I'm not allowed to do this. And he was the parent was furious. He was like, what am my daughter's supposed to go to the library and sit there for 4 hours? She can't do that. Am I supposed to purchase the 20 books that are prescribed in the reading material? I can't do that. We have been relying on course packs all of these years. We've never had to pay for them, and suddenly now we have to pay for them. This seems pretty crazy. So then, yeah, so this is the final slide basically. Back to the theme. Whether there's a fair balance and whether we've reached that. Again, Copyright Amendments 2012 did not focus on education, but the expansion of the fair dealing rights is some consolation, but I don't think it's enough. So looking forward, perhaps these exceptions and limitations under Section 52(1) and A need to be expanded both statutorily, legislatively, and most importantly, the courts need to step in and start taking a wider liberal interpretation of these clauses. Otherwise, there is just no hope, there is just no respite. Again, something that we should possibly be considering in the future is with an amendment to protect the authors of such academic materials is also required. So just the final slide basically is that sometime last month, the president of Costa Rica passed an executive decree expressly allowing photocopying of academic material and also extending the protection to commercial photocopy shops, which is pretty crazy because that's exactly the situation that we're facing in India. And the Costa Rican president had actually gone a step ahead and passed an executive decree. This after several protests by students in Costa Rica, amount to 4,000, 5,000 gathering of students. So basically it comes down to whether another amendment is required to ensure fair balance.
Yeah, thank you, Amlan. We're all familiar with these photographs on Facebook and everywhere. In fact, I'm a fan of Amlan. I'm a keen reader of his posts whenever he writes on Spicy IP. I think he's one of the stars of Spicy IP, and he spoke equally good as he writes. Give him a big hand again.
Thank you.
And he covered a very important topic, the current topic of the course pack case of Delhi University filed by IRRO. And as a registrar of copyrights, I should not take any sides. But as per the government policy, I'm taking what we are arguing in the WIPO, especially in negotiating the possible treaty for limitation exceptions for education research institutions. We have been arguing and emphasizing on the fact that importance of access to knowledge, and these limitation exceptions should not be shackled with the licenses, and also contracts should not override these limitations and exceptions. And then, unless and until these these things are given importance in the international possible treaty, the possible creation of a perfect knowledge society we cannot only achieve, and also the Millennium Development Goals of United Nations, all the countries, developing and least developing countries supposed to achieve, can never be achieved if this kind of restrictions are there and use of copyrighted material for education and research purposes. The issue of course packs has been taken, not probably been taken care by the Delhi University while dealing with this case, I understand. And then if you look at the draft analytical document on questions on limitation exceptions available in the WIPO website, about 61 countries replied to this, and then especially in the topic of limitation exceptions for education research institutions, they mentioned about the how many countries made available these course packs under limitation exceptions. Only 13 countries out of 61 countries gave responses expressly provided limitation exceptions for the course packs, whereas 30 said no, whereas 18 are silent. Out of these 18, 15 countries have no limitation exception for education and purposes. That is very surprising. And then I just take two questions quickly before I move on to I think the first question coming from Mr. Madhukar Sinha.
Amlan, I have been supporting your campaign on spicy IP. Okay, but at the same time, you see what happens is the point that you were making. You made it appear as if it's a one-sided thing, and then the students deserve everything. And these publishers do not deserve anything. They are actually some kind of blood-seeking insects who are just sucking the lifeblood out of the vitality of the education sector. Now, I have a bit of a problem with that. You see, I have been an alumnus of the same institution, Delhi School of Economics. And I have sat in the library for 7 hours, 8 hours. The library used to be open till 12 midnight, at times up till 2 a.m. before the exams and all that. Okay. Photocopying was very expensive at that time. Books were even more expensive. So we had no option. And mind you, the economics, the Delhi School of Economics, at least the master's syllabus, had not changed, and therefore the entire reading list remained for constant for about 20 odd years. So which means that people before me and people after me did the same thing. I'm just putting some anecdotal this thing just to put a stark contrast into the issues. You're talking about 20,000 rupees. When I was going to college in Delhi School, there would be 2 persons at the most, maybe 3, my classmates, who would come in cars or motorcycles. If you go to Delhi School of Economics today, they have expanded the parking area 3 times, and it is full. And most of them are not professors who walk it from their residences. This is the students. So are we really talking about this 20,000 rupees being beyond the means of most of the students there? If they can, or if their dads can buy them cars or motorcycles, they can very well give them that 20,000 rupees. Okay? So I am personally not convinced that the argument is entirely in the realm of affordability of the students. I would buy this argument that a smaller university, a state university, the students may not have it. And so I would like to couch this entire exception business into the Indian reality, that our gross enrollment ratio in the university today is about 12%. That is what the government claims, but many people say it is less than 10%. Our avowed interest is to reach 20% by 2020. Vision 2020, 20% gross enrollment ratio. That would require a massive explosion in the printing industry for students per se. And if this happens now, this is where the inhibition of this target of Vision 2020, 20% would start. I would request you to look at it from a wider perspective, and an absolutely nationalistic perspective about how this can inhibit what Raghavendra was mentioning, one of the issues of the Millennium Development Goals. don't talk too much about the students. Many of the students can actually afford it. They take a night out and spend about 2,000, 3,000 rupees on a party. They do that. Not only in Delhi, I'm certain in your institution also.
Yeah, thank you, Madhukar. And one more issue he has covered in his presentation is about the... Yeah.
Can I just supplement, Shamnath, can I just supplement by a single line?
Yeah.
And this is from a publisher's point of view.
Sure.
First, a factual piece of information. A 900-page textbook for 425 rupees. That's what we publish at. And the second is, if this is a fair balance, by what Amlan stated, if you're going to tip it to a level where it's going to become unviable for the publisher, what is it that you're going to photocopy?
Okay, a couple of things very, very quickly. Lot of supplements, okay, we'll give supplementary answers, yeah, sure.
So that is when it was published. Now what is apparently happening is, the entire book, after reading that, 3 inventors have been able to file patent applications on their own. So for small petty matters, they don't have to go to the lawyers and give them a higher fee. 1. Second, there is one Jan in the book, which is chapter 13. So even if you read the entire book, it makes completely very easy to understand the law. But 13 is a chapter which is the substance of the book, the heart of the book. I am being told by the publishers that the kind of royalty that I was getting earlier, and now I've raised the question that why I'm not getting the same amount, they say there is a tremendous piracy that is happening in the sense that under the fair use exemption, people are copying that chapter 13 and they have stopped purchasing your book any further. So how does the research helps authors like me and the publishers who have taken the task of, at least making me richer for a kind of effort that I put in for my book?
Okay. Couple of things. One is we're restricting a fair dealing scope to educational purposes, right? I mean, we're looking only at what is a good enough copyright exception to suit the interests of educational institutions. And a couple of things. Mark is absolutely right that we have a wide diversity in income spreads across student populations. But if I look at the law schools and I take 10 of the top law schools, yes, out of those 10 law schools, maybe 30%, 40% would be in middle class, upper middle class. What about the remaining? What about the remaining 900 odd law schools? Right? You're talking numbers. If you take the country as a whole, I don't think there's any argument that we're only looking at those children that drive bikes or cars to these colleges. We're looking at the entirety of the country. We're looking at one law. Unless till the time that we come up with a very, very good model of segregated pricing, and you're an economist, Madhukar, you know that that's a pretty tough act to achieve. We need one price. Right? Just in terms of pricing. But the pricing equation is not just about the price of the book alone. The pricing equation is also on the flip side, and you rightly spoke about balance. What is it that we're speaking about? I mean, what incentives are we talking about here? We're talking about academic publishing. Very interestingly, all the authors who are mentioned in this suit, we've been contacting them one by one. You'll be amazed at the level of support that the authors come up and say, we want our books photocopied. We write as academics, if I write being, my salary comes out of the MHRD, I don't want money for my books because I'm already paid to undertake the very endeavor which is educational publishing. So there's a lot of that dynamic going on, and if you speak to a wide variety of authors in educational publishing, a large part of them subscribe to the philosophy that we want this to be much, much more affordable than publishing because our living is not made through these books. We're anyway paid. And our enterprise is such that we need to publish these books. And that's a large component of this. Now, I'll give you another dynamic, which is that if I'm being paid by the government, right, and I write a book, it's taxpayer money. Once the taxpayer has already paid me to support an academic enterprise as an academic, can I then go out on the market and charge the price that I want and double tax? Now, this philosophy is reflected now in the US, where the NIH, right? I mean, if you get funds, federal funds, if you get United States funds for any scientific publication, that article must be compulsorily available on PubMed. A free copy for everyone to access. So the moment you have government funds, now, so this case is not just about, what is the price of a book, what are educational, this is really the entire dynamic of academic publishing. Second, you mentioned royalties, the dimension of royalties. Now, very strangely, again, we've gone back to the authors and where are your contracts? Some of them don't have contracts. So we said, go back and get it. Where are your royalties? Well, we haven't been paid. What happens when your book goes out of print? They don't respond. Like that, lots of things coming out of the closet that we want this one case. So it's not just about this one case. It's really about this entire dynamic that we need to relook at the entire ecosystem of academic publishing, educational institutions, access, and ask the question, how do we fit all that in? I don't know if our judges are well placed to do this policy balancing game, but 52(1)(I) on a literal interpretation, and the way I would read it, and as literal is that it provides enough scope for you to fit in anything done in the course of instruction, either by yourself or through your agent, your direct agent, because Rameshwari is a direct agent of the university. There's a contract by the university which very expressly tells that, look, we can't keep photocopiers ourselves, because that's, what I can do myself, I can subcontract it to an agent who's going to do it on my terms. And those terms are that you will not photocopy it above a certain price. It's almost close to cost price. So effectively, the photocopy is not making a profit here. We could be making profit through other means, but the university just dissociated itself from those activities. It said that insofar as course, and what are course packs essentially? Course packs are aggregated material from a variety of different sources. Our exception is pretty big. On a little reading to cover it. If you want to circumscribe that on a policy argument, we haven't found any credible policy arguments to circumscribe that, given the specificity of.
Thank you, Shamnath. I have offered the work done loan off work. I have to complete 2 distinguished panelists are waiting for me.
I know I gave you the mandate to do.
And then I just would like to tell you about the initiative taken by the UK government. They realized the entire philosophy what my friend Professor Shamnath and Dr. Madhukar discussed about, the importance of limitation exceptions for the growth of access of knowledge, especially not only the elementary education, the higher education. And you remember the section 25, I think, the CDP Act of 1988, that's the Copyright Design Patent Act of UK. They restrict the photocopying for the education purpose, only 1 chapter, 1 poem, something like this. Unfortunately, this is put here without interpreting what is explained by Shamnath about 52(1)(I), and they have started reviewing their exceptions. They are fed up with these kind of restrictions, because the access to work will not be freely done. So they started a review under Professor Hargreaves, the famous Professor Hargreaves review, and then Price Waterhouse has come out with analysis of this review, very interesting documents. I think Amlan can go through this and write a post on that in future.
So
and now I'm
one short response.
Yeah.
Just one short response to you, ma'am. The reason that authors support photocopying is because I can speak as a student. Photocopying almost acts as an advertisement for the sale of the book. Eventually, I know, ma'am, you might have an issue at the moment, but I can tell you as a law student, I have photocopied several extracts or chapters of text. For example, even Mr. Anand Padmanabhan's book, I might photocopy a chapter, but when I enter into practice and I have the money, there is no reason for me to not purchase that book. I will not require just that 1 chapter. I will require all 8 chapters, and I will have to purchase that book. And I can assure you, ma'am, if I have the money, and I'm sure I will when I start to begin my practice, I will purchase that book, ma'am.
Thank you. Please.
Also,
we'll discuss later. We'll discuss.
It does, no, ma'am. Ma'am, merely because I'm exercising my fair use.
Please, we'll continue discussion later. Thank you. Big hand again to Mr. Amlan. And now I request